A verdict was reached in the Tickle versus Giggle case, and the verdict was against Giggle and Sall Grover. While this verdict is disappointing, Sall Grover said that it was the outcome she anticipated. It is, whether we like it or not, consistent with the precedent set in the application of Australian non-discrimination law, which recognizes gender identity. Welcome to another LGB Alliance USA News Roundup. We are here with Carol and me, Ari Ann. First, we'll begin with a summary of the news for the week ending in August 23rd, 2024. A judge ruled a boy can play on a girls' soccer team in New Hampshire. An Ohio judge allows a former teacher who refused to use preferred pronouns to go to court. Texas A&M announced it has ended transition-related health services. The U.S. Supreme Court upholds the blocking of new Title IX rules in 26 states. The UK renews its ban on puberty blockers, and a judge in Australia ruled against Sall Grover in the Tickle versus Giggle case. With that, I'm handing it to you, Carol.
Thanks, Ariane. Okay, so on Monday, August 19th, Judge Ladia McCafferty ruled that a 15-year-old boy can play on the girls' soccer team at Plymouth Regional High School in New Hampshire. This ruling comes just days before a new law mandating sex-segregated sports in public schools was set to go through in New Hampshire. The ruling is only a temporary ruling before the scheduled hearing on August 27th, and only applies to the two boys who brought the suit. The boys are being represented by Chris Urchel, senior staff attorney at GLBTQ Legal Advocates and Defender, who argue that the law violates Title IX protection. We will keep you up to date on the story as it unfolds. Up next, Ohio. So an Ohio federal judge ruled that a case involving a former teacher who resigned instead of using preferred pronouns in the classroom will be allowed to proceed to trial. According to Bloomberg Law News, Vivian Gehardy established without a trial that requiring her to use preferred names and pronouns amounts to compelled speech, that the speech didn't involve her ordinary job duties, and that Jackson local school district's policy on the issue wasn't generally applicable. So the main issue that must be answered in the upcoming trial are whether allowing middle school students to choose their names and pronouns is developmentally appropriate, and whether Vivian resigned voluntarily or had no meaningful choice. Judge Pamela A. Baker stated that, quote, only after a jury answers those questions can it be legally determined whether the interest of the school board and three officials in requiring Vivian to do what students prefer outweighs her First Amendment rights. Vivian is being represented by Alliance Defending Freedom and Gallagher, Kavinsky, and Burkhart LPA. Texas A&M has ended its involvement in the practice of transgender healthcare. A&M informed students on July 1st that it would stop offering trans-related services a month before the change went into effect. University spokesperson said its growing student population and the resulting strain on the health center requires officials to continuously review services they offer and how they use the center's resources. She said they decided that putting more resources into mental health was a better use of their funds. The spokesperson noted that the university has invested more in mental health care following a national rise in college students seeking it out. A&M started providing students with cross-sex hormones in 2012. It was one of only a few universities to offer this to its students. According to the Texas Tribune, 6 other public universities confirmed that they do not provide any transition services, and several other universities that were contacted by the Tribune declined to answer. Of course, this is being reported in most mainstream news outlets as a, quote, attack on LGBTQ communities. For example, the Queer Empowerment Council stated, quote, Texas A&M is directly harming the mental and physical health of its student body. But the fact is that many gays and lesbians are and have been harmed by trans healthcare, as we have seen by the number of detransitioned lesbians and gay men that have been speaking out in the last several years. So who exactly is the Queer Empowerment Council speaking for here? And who is our major LGBT organization speaking for? They definitely aren't speaking for detransitioned lesbians and gay men. They aren't even including us in their conversations. And that's all I have for today. Ariane?
Thank you. An excellent point. So first, I'm going to talk about the Supreme Court. So on August 16th, the Supreme Court ruled in a 5-4 decision in favor of preserving preliminary injunctions blocking Biden's Title IX implementation in 26 states. Now, let's clarify what this does and does not mean. It does not mean that Biden's Title IX changes are now dead. It does mean that Title IX changes, the Title IX changes that were implemented by the Biden administration will remain temporarily blocked in these 26 states while the legal challenges to their provisions from these states work their way through the courts. So another thing to bring up is that all 9 of the justices on the Supreme Court agree that these 26 states were procedurally entitled to block parts of the Title IX implementation that involved 3 controversial provisions, and that included the provisions that redefined sex discrimination to include discrimination by sexual orientation or gender identity. However, the 4 dissenters on the court argued that blocking the Title IX implementation as a whole was overly broad, and that only the specific controversial parts of the rules should have been blocked. So Judge Sotomayor, who wrote the dissent, pointed to specific provisions involving pregnancy and marital status discrimination that have nothing to do with gender identity and are unchallenged, and hence, in her opinion, should be allowed to go into effect. The court's other 2 liberal justices, Kagan and Brown-Jackson, also sided with Sotomayor, and as well as perhaps more surprisingly, Gorsuch, who normally votes with the conservative bloc. But the rest of the conservative bloc, including Alito, Kavanaugh, Barrett, Thomas, and Roberts, joined the majority decision. The majority decided that it was not possible to sever the controversial provisions of the Title IX rules from the rest of the rule implementation, and hence they concluded that it was fine to block the new Title IX rules in their entirety in these 26 states. In other words, this was a procedural decision that does not arrive at a definitive verdict about Biden's new Title IX policy as a whole. We'll have to wait to see as the state's legal challenges to the Title IX rules work their way through the federal court system, and we'll keep you updated on that. Next, turning to the UK, on August 21st, the UK extended its temporary ban on puberty blockers. While the old ban would have expired on September 3rd, this new order extends the ban to November 26th of 2024. Furthermore, the UK extended the ban to include Northern Ireland, closing a loophole that existed in the previous ban. And this decision is just more momentum in the UK's movement against pediatric medical transition. Finally, we turn to Australia and the Tickle versus Giggle case. A verdict was reached in this Tickle versus Giggle case, and the verdict was against Giggle and Sall Grover. Now, what's the background on this case for people who might not know? Giggle is an app developed by Sall Grover that is female only and uses face recognition technology to enforce this rule. Roxanne Tickle is a trans-identified male who claims he was discriminated against by this app. And so he sued, and the judge affirmed in his verdict that sex is legally changeable and that gender identity is protected under the law. And the judge ruled that Tickle was indeed indirectly discriminated against on the basis of gender identity, though not directly discriminated against. And so consequently, Tickle was awarded $10,000 compensation plus legal costs up to $50,000 in compensation due to be paid in 60 days. While this verdict is disappointing, Sall Grover said that it was the outcome she anticipated. it is, whether we like it or not, consistent with the precedent set in the application of Australian non-discrimination law, which recognizes gender identity. And we're still waiting to see what steps Sall Grover intends to take next. She says she's going to continue fighting the fight, and we're going to see how exactly that might play out. So, what are your thoughts on this, Carol? This was a very heavily anticipated trial.
Yeah, I actually feel kind of bad for her because she was like, yeah, I knew that's the way it was going to go. I mean, I'm really struck by how crazy Australian law is around this whole gender identity thing. And really that's the ultimate, that's the pinpoint part of it, right? Gender identity, recognizing that upends everything because anybody can claim a gender identity. It has no basis in reality. I think it's just been wreaking havoc in law.
Yeah, exactly. I mean, in some sense, it's not clear if there really is this precedent in Australian law for recognizing gender identity and recognizing discrimination on the basis of gender identity. It's not even clear what a judge could have done otherwise. I mean, that's just the reality of the legal situation. And I thought it was interesting. I did watch the live stream of the judge's announcement, and I was trying to follow all the nitpicky legal intricacies of what he's saying. Not that I know anything about Australian law on this point. But like one point he brought up was how he didn't think that Tickle was directly discriminated against on the basis of gender identity. The idea being that would require that the makers of the app deliberately, consciously didn't let him onto the app because I guess he was, trans identified. But he said that they indirectly discriminated against him by having this software, this facial recognition software that was designed to weed out, people
Men.
who were not cisgender, use that language,
Oh, okay.
women. Um,
Well, so then this wouldn't this ruling be then that this just breaks down the ability to have sex segregated spaces, right? This breaks down the ability for a privately owned app to have limits and regulations on who they let in. I mean, it can, I just like, can you do that? That's kind of like,
yeah, I mean, it's scary that it extends the reach of this to like even something that's software, something that's online. We're not even talking like you have to rent a country club, you know, in order to do this. This is like just online. And I'm curious what sort of precedent this sends. I mean, I, once again, I don't know Australian law, but what about things like online forums or whatnot? It's very, yeah, it's
do you know if do you know what the precedent law was around gender identity stuff there? Or is it just been that gender identity's always trumped sex in their law since it went
Um,
into, or the
the short
non-discrimination
answer
thing?
is I don't know. There was a law called the Non-Discrimination Act, and I don't know if that was something where it was written from the get-go to involve gender, to include gender identity, or whether that was just a legal precedent that was later set. I did read a tweet, I think it was from Bernard Lane is his name, in which he said that when same-sex marriage was legalized in Australia, they didn't like explicitly say like, okay, now marriage can be between two members of the same sex. They said it was now like about they rewrote the whole marriage law, so it's about you can marry someone regardless of gender.
Oh,
Like they switched
yeah.
out there. Um, there was another thing that was brought up in the hearing, which was where the judge rejected another claim made by Tickle about the was it the protocol against violence against women or disgrace. It's a very old sort of policy. I think it may have been an international policy. Um, and he said it was irrelevant whether or not that old policy would have included gender identity, but he simply said he didn't believe the motivation behind excluding Tickle like was putting down women, which was the initial intent of the rule.
Well, of
This
course
was
it's
all
not
like,
because he's not a woman.
I mean, this was all sort of, technical legal jargon, but yeah, I mean, I'm curious.
I also find just his name hilarious. Like you couldn't get a better name for a creepy dude. Like have you seen
Yeah,
him? Oh my
yeah.
god. I just this whole thing, it's I don't see. I remember when that app first launched. Do you remember if they had a section for lesbians or dating? Did that app have a dating out element to it?
I didn't think it did initially, but I admittedly never used the app,
Okay.
so I don't know. I thought that was something she was thinking about implementing.
I think so. I think that's maybe what I had heard. And I mean that really goes this kind of stuff really goes to the heart of, lesbian spaces and same-sex attracted people spaces, right? Dating apps. And when we see this stuff all over dating apps where men are in there claiming to be women and vice versa. So I don't know. This is just very concerning. It's really stepping on everybody else's boundaries.
It is. And I'm curious what can actually be done in this case. Like if there's some hope for some sort of appeal, and if so, what would be the legal basis for it if it really is the case that Australian law is so cooked
I mean,
on this?
it's kind of I don't know. And like I said, we're not super familiar with Australian law, but here in the United States, I really think what needs to happen, and this is what a lot of feminists have talked about, is we do have to have something implemented in government, basically, that states that sex is the thing we're going to go off, not gender identity. Like, that's what we're putting in law.
Well,
You never had to actually state that before because everybody knew what a woman and a man was. But now you have to actually state it.
yeah, even something that did recognize gender identity but didn't let it trump sex. I think that was a point Candace Jackson made in an interview we did with her, that you could have a provision that banned discrimination on the basis of gender identity in the same way you could like ban, discrimination on the basis of religion. If you
Yeah.
have a policy that says this is going to be on the basis of sex, all women, and you didn't want to discriminate against a woman who identified as something else or something. I don't know. I mean, that's a whole different can of worms. Like if you're gonna have a female only space, um, okay, so then are you gonna allow females that identify as men or non-binary or what?
Well,
That
if it's based on sex, then yes.
Yeah, presumably if it's
Yeah.
on the basis of sex. So yeah, we need to make sure that sex is a perfectly valid protected trait and it shouldn't be redefined. That was really what was disturbing a lot of people, is the judge saying you could change sex.
Yeah. Well, that's not factual. That's not scientific at all. Like you can't. These are cosmetic surgeries
Yeah,
that make have people appear sometimes to be the opposite sex, but it doesn't change their sex.
yeah. It's like a case of using a legal fiction to override a biological reality. That's what's disturbing. It would be like if we changed adoption laws to say that biological parents, that they can lose custody of their children if someone else claims to adopt them or something
Yeah,
like.
it's just like you can't. Yeah, you cannot claim an identity that you aren't actually that. Like that's just not.
Yeah,
Well, I'm curious to see what happens with this case, honestly, because Australia is one of the more um, unhinged. They have some of the more unhinged laws when it comes to this. So I'm curious to how this plays out.
yeah. I don't know why the Anglosphere, the former colonies of the UK, seem to be so crazy. I mean, it's kind of like the US and Canada, so
Yeah.
we have our problems.
Maybe because it's so hot and crazy down there. I don't know.
Yeah, I don't know, maybe. Well, anyway, thank you all for watching. Remember to like and subscribe. And if you want to learn more about our organization, if you want to find out more about what events we have to offer, or you'd like to make a donation to us, please visit us at lgbausa.org. And we hope to see you again next week. Thank you.